What is a red flag in a case law or in a case? Well, a red flag is either that the case got overturned or somebody used it in an argument trying to get either the same opinion of the court in regards to the interpretation of the law, or they had a criminal case and they said this person got this time, I should be able to get this time instead of more time. And the court refused it for some type of procedure or some type of argument. So when that happens, it gets a red flag. For example, the case where people had a right to abortion. It was a constitutional right to privacy under Roe versus Wade. I believe I'm saying it right. So somebody used it, the case got overturned now, so there would be a red flag in there. So somebody would say, "Oh, well, I got the right to have an abortion," and they would use Roe versus Wade. And before that got overturned, it was good law. But now they can't use that because it got overturned. So now it becomes a crime to do abortions. Okay. So another way that it becomes a red flag is not because it got overturned, but because the person that used the argument in their situation, it didn't come out the way it was supposed to come out. They argued it wrong, or they didn't argue it correctly, and the judge said no, this situation is a slight different, or for some reason legislation was passed to overrule that case without turning that case over. So now it becomes bad law. But sometimes, even though it has a red flag, it doesn't mean that you can't use it. For example, a case that somebody, in criminal cases, for example, somebody does something and the decision said that when this specific crime occurs, the person got 2 years. Now, when you go to court and you use it, the court is trying to give you 4 or 5 years. You say, well, look, this is the same exact situation, so I'm entitled to 2 years under this case, and it would be fine. But certain things probably get turned over, and then it creates a red flag. So you always got to see the red flags when it says red flag. But it's not always necessarily true that a red flag cannot be used. I mean, not a red flag, a case that has a red flag, because your argument could be different. So, let me see, how can I put this? A red flag could overturn the case in regards to the situation, but the law, no, not the law, the opinion of the case still has some positive in it. So the case says, okay, you still need due process in order to determine a guilty verdict or determine some type of monetary value to the winner. But the red flag would be in the type of awards or penalties. So it says, no, listen, the case says, yes, I have to give you due process, but it got overturned under 2 years. So I can no longer give you 2 years. I can still give you 5, 6, 10 years. I can even give you time served. But regardless of what I can give you in regards to that case, is that I still have to follow due process. So the red flag can pertain to a certain specific ruling in that opinion, but not necessarily the entire case. But a red flag is usually something that you may have to call out. Like in Swift, Erie Railroad versus Tompkins overturned another case. So the other case said that the courts had an unconstitutional act. So that means that they could disregard your constitutional rights. But the guy that appealed, and they got the case of Erie Railroad versus Tompkins, is that when the court took it in to hear the lower court case, it said, listen, we have to follow certain procedure when an appeal is brought. But we have to note that there's two types of citizens. Citizens at the common law and citizens at the national level. So they're state nationals, but the way it's used in this case, it doesn't say state nationals because state national will be a common law. So, so Erie versus Tompkins stated that there's two types of jurisdictions in each state, which is common law and national level, which in that case means that you're a U.S. citizen or a state citizen. So when you challenge jurisdiction, a lot of people challenge jurisdiction. They will say, well, Your Honor, do you have, the Constitution says that Article 6, the Constitution says that two types of criminal jurisdiction, either common law or maritime or military tribunals. So you would challenge that. So they say, well, this is statutory jurisdiction. Well, I don't see any type of defenses that says that the statutory jurisdiction exists, even though they use it every day. So people usually challenge jurisdiction and they lose. So when you gotta challenge it, you would use a lot of cases in regards to you can challenge jurisdiction at any time. You can challenge jurisdiction at a before, after, or during appeals and post convictions. All that. But Erie Railroad versus Tompkins, you could say, well, Your Honor, on the Erie Railroad versus Tompkins, there's citizens at the common law and citizens at the national level. And I'm asking you that on the other cases, with this case says that you have to prove that either I'm a party to this or I'm a party to that. And if you can't prove what I'm a party to, then you have no jurisdiction. And that's how you would use that. I'm gonna put up a video on challenging jurisdiction. But at the low level, which is either criminal court or the Supreme Court, or the criminal levels, right? Felonies and misdemeanors, or United States District Courts, which is the lower level, which is like a trial court, because it goes up. These are the lower courts. So the United States District Court is the lowest court at the federal level. So if it's civil, you would challenge jurisdiction on the House Joint Resolution 192. Which people use for challenging the money value that the United States went bankrupt and all that. So what you would do is you would say, Your Honor, what is a bankrupt corporation? It's civilly dead. So if it's civilly dead, how can a prosecutor, meaning the federal prosecutor, this is a federal level, you would say, so how can a prosecutor have standing? And then you would challenge it with Erie Railroad versus Tompkins. Be like, because there's citizens at the state and the national level, right? So if he represents the United States, Your Honor, I would like to see his card, his bar card, so I can make sure that he gets the paper. When you take the bar card, they give it to you, which you have to request it. You're gonna be like, Your Honor, he doesn't even have a right to speak. The United States is bankrupt under House Joint Resolution 192. So when they bankrupt, they're civilly dead. So that means they can't even prosecute criminal or federal when you challenge jurisdiction on Erie Railroad versus Tompkins. They got to prove jurisdiction. So that means that the only way they could proceed is on the bankruptcy court. And if it's not a bankruptcy court, then he can't continue. And if he is, he has to be a trustee for the United States, because only a trustee can speak for a bankruptcy court, because they do the dissolution. They're the ones conducting the whole trust. The Constitution of the United States is a trust. It's a public document. So the people were the grantors. And the trustees are the governments. And the citizens, it depends on how you use it. Because you gotta say, when they ask you, are you a citizen of the United States? Well, Your Honor, before we get into the citizen part, what definition are you using in regards to a citizen, and where did you get your definition? Because there's citizens at the national level, there's citizens at the common law level, and they all got different rights and different procedures. So that's what you would do. But always challenge it. Now, what you would do is you would go to a law library, you will pull out the document, and you will have the court certify it or apostille that document of decision. So if you go to the court and you get a House Joint Resolution 192, and then you tell the court, usually the court clerk, listen, I need you to certify this document. This document is the actual and accurate record of the government, which is case law, which is statutory law. It's all that, act, a policy, whatever it is. You want to get it an apostille. Apostille is some type of government authentication that it's a real document. So what you would do is you get that. That's what I would do. I would get it. I would get an apostille and I bring it into any federal court case I have. You know, and then you challenge standing. You challenge standing with standing criminal court. You know the standing is for you, saying that whatever law they're using against you is unconstitutional or whatever. Now, if it doesn't affect your constitutional rights, you have no standing and they will prosecute you. But you challenge jurisdiction, you say, yo, Your Honor, he can't even speak. He's not, a bankruptcy court is civilly dead. He's not a trustee for the United States. His bar card doesn't even say trustee. His card is supposed to show his member, but it's to show that he's a trustee and he's not a trustee. So how could that be? And every federal court, I haven't found the exact code for this, but they have to get permission from Attorney General. So you would be, Your Honor, you would say to the prosecutor, did you even get permission to prosecute this case? Oh, well, no, but we can get it. What? So you're just harassing my client. You're just harassing, because you never become the defendant. You would say, so-and-so on behalf of the defendant. Defendant, when you look up the definition, you got to go to the oldest Black Law's dictionaries. A defendant is a dummy. It's a dummy. And when they refer to the dummy, it's like it's not a dummy like you can say a dumbass, how people would use that word. A dummy, it's like a fake puppet or tranquilitist. I can't say the word, but you know, the tranquility is somebody that you move and control it when you put your hand in and they start talking like this. So that's why you never want to be defended. Defendant is civilly dead. So always check the documents. Check the flags. If the flag is negative or positive, positive is always good, because you want to make sure that if you are losing, you want to make sure they follow procedure, because you could get a case overturned for them failing to follow procedure. They will give you a trial de novo. So de novo means a space new, like a new trial, new hearing. So some people, when they appeal, if I have to appeal, I will be like, well, I want this appeal to be heard de novo. So you basically bringing it. They're not gonna look into the facts. The facts was that he got into an accident. The fact was he had a gun. The fact was that something happened. Those are the facts. Now, what you want to use is the law. So what law are you using? This law or that law? Now you want to make sure it's positive law. Now, when you go into the Congress page, congress.gov, you look up a statute, an act, or United States Code, or federal rules, FRCP, Federal Rules of Procedure. No, it's United States Code or FRCP. I can't remember it right now, but I will get it. But you look it up, and then in that government website, you have to check. They usually have some type of little signs in it. You have to find where it says what a sign means. Now, it's like a little star or circle or dot or square or some type of mark next to it. And then when you check the mark says that it's been enacted into positive law. So now, for example, you can go into the tax code. The tax code, it's positive law, but only the title. And when you check under it, it's never been enacted in positive law. So how are they filing taxes? Taxes is voluntarily. So once you volunteer, you bought the whole farm, you know? So now, it's hard to get out of it. Now, one way to get out of it is when you sign a document without prejudice. So you put W-O prejudice, which falls under Uniform Commercial Code 1-308. Before it used to be 207, now it's 1308. You would sign a driver's license without prejudice, UCC 1-308, and you would sign. And then they're not gonna allow it in DMV. So what they ask you, what's this? You'd be like, oh, that's how I signed for tax filing purposes. So they don't want to deal with the tax. Taxes get people audited and they leave you alone. Well, this is how I signed to identify as me for tax reporting purposes, and they allow it. So now, when you get a driver's license, you don't have the full disclosure. So in there, you are consenting to the implied consent law. When you got a driver's license, you consented to say, listen, take my breathalyzer, take me out, put me out the car, arrest me for any traffic violation, every infraction. You're agreeing to that. But when you sign without prejudice, you're going to submit the Uniform Commercial Code. You're going to say, listen, I reserve my rights, Your Honor. So I do have a license, but it is out of convenience and not consideration. Convenience because every time I get stopped by the cops, they harass me. I don't have this, so I signed it, but I reserve my right. So now, if I'm a driver, I'm getting paid. But if I'm not getting paid in a specific moment, my rights are reserved that I am traveling. I'm not driving. So the highest case law on traveling is Shapiro versus Thompson, which says that they can't create any law, statute, policy which infringe a citizen's right to travel. They should be unencumbered, meaning they can't bother you. But they do, because you're in a car. They don't know the difference between an automobile and a vehicle. Usually, some people argue it becomes both, but you gotta prove that you're not getting paid, that you wasn't doing that for some type of monetary value, you know. And then you want to look up Title 31. I believe it's Title 31 and 48. Those two titles says a driver is somebody who's engaged in commerce. So you got to bring up these codes. You get them apostille. You save them now. You keep them in the record. You keep a file already. So God forbid you are somebody who's what they call a sovereign citizen. You don't want to be a sovereign citizen. It's two words put together, it becomes an oxymoron. Either you're a sovereign or you're a citizen, or you're both but separate. So citizens are usually sovereigns when they know how to enforce their constitutional rights. When they don't know how to enforce it, then, you know, you become a U.S. citizen. But then again, you got to know how to make your arguments. You know, there's people that say, I'm a U.S. citizen, and they got all constitutional rights. Why? Because they use the Supremacy Clause, which is Article 6, Paragraph 2 of the United States Constitution, says anything contrary is null and void, meaning there's no law. So make sure you look up the stars, see what case you want to use, learn how to challenge jurisdiction. The fastest way to challenge jurisdiction is, Your Honor, listen, I understand I'm not an attorney, but I want to fire my attorney on the record for 5 minutes. The reason I want to fire him is because it is my understanding that when I challenge jurisdiction, I have to do it. He can't do it. He works for the court, so jurisdiction is granted. So I want to make my argument. If you don't dismiss, at least I appeal. I object on the record as an appealable issue, and then he could come back. I'm not waiving that right to counsel. I'm just saying that I want to submit this defense, and in order for me to defend this jurisdictional challenge, I have to do it on my own. So that's what you're gonna do. And you're gonna say, Your Honor, under Prato bail bonds versus state, it says that I could challenge your oath of office, and I need you to submit your oath of office that you filed it in a timely manner, and that you submitted your anti-bribery statement form. And even if you're not sure about the anti-bribery statement form, it says that you have to submit your oath of office. You have to do it in a timely manner, or else the case is moot. And if you can't present it today, let the record reflect that I challenge your authority. You don't have it, and it's moot. No respect to you, but to the person that's being the judge in this specific position, what happens to be you. And if you don't have it, my objection is on the record. And now that I have challenged it, I retain my attorney again, which it could be public counsel, private counsel, depends on your attorney. So that's what you would do. And on appeal, you're going to win. They're going to say, go check if he got an oath of office. If he doesn't have it, the case is moot. So now what did he do? He impersonated a judge. And you could sue him personally. And, you know, there's a lot of ways to defeat the court. Thank you. YouTube. I have more content. Just comment and ask something. I have a lot of information. I need you to ask me anything in regards to Constitution and criminal and civil actions. And Constitution applies to everything. Marriages, contracts, everything. Every Constitution is up here. And everything under it comes from here. Remember that.